we're off, Mr. Undy.
Sorry, Chief Justice. As the Court pleases, freedom under law seeks intervention in these proceedings in order to bring to account and ensure the constitutional responsibilities of the Minister, SASSA and CPS are ensured through proper supervisory orders that we have asked the Court to make. Our submissions will be divided into two main parts. The first of them will deal with the question as to what are the principles that emerge from the All Pay case, All Pay 2 and All Pay 3, and where does the Court derive its jurisdiction in order to grant remedies, whether of the kind that we seek or the variances of it that have been sought by various parties before this Court. The second part of our submissions will go to the specific orders that we have sought and deal with some of the objections that have been raised by SASSA and the Minister on the one hand and CPS on the other. You will have seen that in principle the orders are not opposed, but some of the detail of those orders are opposed as to their scope and extent, and we will endeavour to persuade the Court that the orders that we seek are warranted and necessary in the light of the present circumstances in which we find ourselves. If I could begin by dealing with the fundamental holdings that emerge from All Pay 2, because they have a direct bearing on the question of the jurisdiction of the Court. In All Pay 2, and as further summarised and emphasised in All Pay 3, there are three fundamental principles that emerge from this, from these judgments. The first is that there is an ongoing obligation that CPS has to render the services that it does, and it is required to discharge those obligations even after dissolution of the contract. So there is a constitutional obligation resting upon CPS as an extension of the state, and it cannot, to use the language of the Court, walk away from those obligations. So, and I'll come to this under the head of jurisdiction, even if the current regime were to run its course, it would not excuse CPS from its ongoing obligations to discharge its function until a proper system is put in place which bring the scheme of distribution of grants within the scope of legality. That's the first proposition. The second proposition is that CPS, burdened with these constitutional obligations, has no right to benefit from the discharge of its obligation. It is true, as the Court has indicated, that it is not required to discharge that obligation at a loss, but it is not permitted to benefit. And that means, put into ordinary language, commercial language, it may not profit as a result of the unlawful contracts that it has enjoyed in the past, nor may it profit from the discharge of its constitutional obligations for the future. And the third proposition that emerges from All Pay is the duty of accountability and the circumstances in which what is now done for the future must meet both the requirements of accountability and the requirements of transparency. Now, in the light of those clear pronouncements by the Court, it is our respectful submission that much of the relief that we are seeking on the basis of what must be done for the future simply flow from the obligations and the principles that have already been determined by the Court in circumstances where it determined the remedial regime that would flow from the invalidity that it found in respect of the 2012 contract that was granted to CPS. If I could then deal with the question already engaged by this Court with my learned friend Mr. Budlander, which concerns the questions around both jurisdiction and remedy. In our submission, there are at least two ways in which this Court can assume a supervisory jurisdiction for the purposes of providing a proper regime for this most important state function of distributing social grants. The first is that it may perpetuate the suspension regime that exists already. Now, it is true that this court thought it was in a position to discharge its order because it was proceeding on a premise which turned out to be false, which was that SASSA would indeed be in a position to distribute the grants as of the end of this month. But as we now know, that factual premise for the discharge of the order was false. In those circumstances, we submit that the court, since it still is within the period, the suspension period that it ordered, may again take up its supervisory jurisdiction for the purposes of extending the regime that will be applicable to an ongoing suspension for a finite period of time. We submit that that flows, amongst other things, from what this court had to say in the Zondi case, Zondi versus the MSc, Tradition and Local Government Affairs, 2006 3SA 1, a decision of this court, where the court was again faced in that case with a circumstance where, having granted a suspension, the relevant government body had simply failed to do what was required within the period granted for the correction that was required. And what the court said in those circumstances is that the court can, not only can, but must in certain circumstances discharge an obligation to vary the terms of the suspension so as to ensure that the just and equitable jurisdiction that it enjoys is properly applied and a proper remedy is achieved. So those passages you will find from paragraph 38 to paragraph 40 of the Zondi case. In our submission, that is the first basis upon which this court may assume jurisdiction, because we are still within the period of suspension, and the court may take up its powers to ensure that a just and equitable outcome arises. And that is most pertinent following some of the questions raised by the Chief Justice and other members of the court as to the imminent emergency that we find ourselves in, which is that as we stand at the moment, it is very unclear on what basis and in what time period it is going to be possible to ensure what everybody takes as absolutely necessary, which is that the grants will be distributed at the end of this month and on the 1st of April. Now, in the light of the fact that the recent correspondence from CPS would indicate that if they are not placed in a position to start loading these grants, as I understood the correspondence, either today or tomorrow, there will be an interruption. And hence, so it is said that there is no time for a period of contractual negotiation to take place, whether under the auspices of Treasury or otherwise. Now, whether that is factually true or not is hard to say, given the manner in which papers have been filed in this court. But if it were true, then there would be urgent circumstances which in our submission would suggest that this court should in the first place extend the current regime on the current terms and conditions that now pertain to CPS's discharge of its constitutional obligation for at least a period of time necessary for what has been referred to in these papers as an interim contract. In other words, there is the first thing that the court would do would be to simply extend the status quo under its supervisory, just and equitable jurisdiction for there to be a determination of an interim regime, which would then follow after the extension period. And then ultimately one would make that as brief as possible, that is to say the interim contract, so as then to put in place what will be the final regime. So that would be a three-part regime: an extension for a period of time, an interim regime, and then a final regime. That is one way in which the court might proceed. The other way in which the court might proceed is to consider a supervisory jurisdiction and remedial orders that arise in a separate way. And that, we say, flows also from the determinations of this court in Allpay. It is peculiar to CPS that CPS, having been an incumbent and having benefited from its incumbency, is saddled with the obligations to continue to discharge the services this court has found after the end of its current contract. And that is a constitutional obligation that it has. Once that constitutional obligation is recognized, as this court has recognized it in Allpay too, then the only question is, well, how will that constitutional obligation be carried out? And the submissions that you have heard from the parties and the remedies that are proposed are all supervisory orders consequent upon the discharge by CPS of its ongoing obligation to render these services until legality can be restored. And legality can only be restored, as this court previously held, in one of two circumstances. Either SASSA takes this over and actually does what it says it will do, which it hasn't done in the past, or there is proper procurement of a service provider under the requirements of 217 and the subordinate legislation to ensure that legality is restored. But in the interim, CPS cannot walk away, and it cannot stipulate for terms that it would consider commercially valuable to it because of the no benefit principle that this court has already enunciated. So the remedial regime that we look to is simply an incident of the constitutional obligation that this court has already saddled CPS with, and which this court could continue to insist upon in the interim regime until legality can be restored.
Mr. Unterholt,
yes,
just to practicalize the issue. Under what circumstances would it be open to CPS in the event of, say, the extension of the pre-existing contract for it to say, I'm not going to carry it out, these terms are unfavorable to me?
As we understand the relevant dicta in Allpay 2, it has no such ability. It is required to discharge this obligation. It is not a question of its commercial interest. And the only requirement is that it cannot be expected to do this at a loss. But it may not secure a benefit from it. So what this court has said is that one of the consequences of the incumbency that it enjoyed under an illegal contract is that it can't choose the manner of its leaving, and it is saddled with the obligation to continue. It cannot walk away. So were it to seek to do so, it would be in violation of its obligations, and this court can discipline CPS in the discharge of that obligation, and it would be in contempt if it didn't do so. And all of that is done for as short a period as reasonably possible to restore legality under a new system. So obviously it is an onerous obligation that it must carry, but of course it has benefited for many years from an illegal contract. And so that is the equipoise that this court has introduced into the scheme of rights and obligations that exist.
Mr. Butlander has suggested 6 months. What is achievable within that period?
Well, Chief Justice, as I've indicated, there is a tripartite model and there is a two-part model. The tripartite model is extend the existing contract, then have an interim contract, and then move to, let us call, circumstances of legality. The two-part process says no. We simply hold CPS to its obligations for a period, and that period must be a period sufficient for SASSA and the minister then to hold a proper tender. If that remains what seems to be the case, the only viable way of having these grants distributed, because, as I think you have already raised, SASSA at the moment is insufficiently capacitated to do the job itself.
Well,
and I should just say finally, 6 months may be too short a period under the two-part model. It may be that something more is required. The consensus seems to be about a year.
well, yeah, I would, or you say about a year?
We would think that given the false promises of the past, it doesn't make sense to have too short a period because everyone will just be back here, hopefully in good time. But what we are looking for is a solution which will be durable and actually be carried out. And we would have thought that probably 12 months is a plausible period to restore, within which legality could be restored.
Mr. Unterrater, referring to the continuing constitutional obligation that CPS has,
Yes.
in OPE 2, that was stated in the context of the situation that obtained then of a 5-year contract. If one extends that contract, there must be a finite term
Yes.
for the continuation of the constitutional obligation.
Yes.
And firstly, that's the proposition I put you. And then secondly, given that the OPE 2 was decided in that 5-year context, isn't it open for CPS to say, well, it is just for us not to benefit from that for 5 years, but if we are told to continue, then at least we must be given an opportunity to try and convince the relevant authorities, which may include the Treasury, that we're entitled to something more. Do you have anything
Yes,
of assistance in that regard?
If I might have 3 short submissions on that. The first is that in paragraph 64 of all pay, it is said, but even after the dissolution of the contract, but before the appointment of another service provider, cash paymaster will have constitutional obligations, and the court then explains what those are. So it does appear that this ongoing obligation is recognized, but it carries with us, as I've already conceded or certainly recognized, that because it could be onerous, it mustn't endure any longer than is necessary for the purposes of restoring legality, and therefore it must be of a fixed term, and 12 months may be the term that is warranted. The third question is whether there should be a relaxation of the no-benefit principle for the purposes of this further extension. In our submission, there should not, because, and I'll come to the facts in a moment, on the facts that are presently before the court, CPS was pertinently required to state what profits they had enjoyed over the 5-year term that they had enjoyed this contract. And although they speak to cost of living, CPI increases and certain particular costs that they have incurred, they never squarely explain what the accrued profitability has been, and we have advanced, as we did before this court in All Pay 2, that they were profitable from year 2 onwards. And so if one is again...
I'm sorry to interrupt,
Yes.
but isn't that still to be sorted out in terms of the remedial order? There must be the expenses, the income, and the profit must still be disclosed within 60 days after the 5-year period. It must be audited and the like. So it's not possible at this stage to say what is and what isn't the profit.
Justice
But it's a principled question.
Yes.
It's now a further period. Shouldn't there be, and I'm not saying the court should decide it, but shouldn't there be an opportunity for CPS to convince whoever may be the proper statutory authority, it might be the Treasury or whoever, to convince them that they're entitled to something more?
Justice Frinneman, the issue is whether there should be a relaxation of the no-benefit principle. That's the question at stake. We would submit 2 things. Firstly, there should not, because they have enjoyed considerable benefit under a 5-year contract which has been profitable to them, and as an extension of the state, now to seek to make yet further profits out of an avowedly unlawful extension necessitated by the urgent circumstances in which we find ourselves is not warranted. There should be no circumstance in which the discharge of the constitutional obligation means that a party such as CPS can profit through unlawfulness. And we submit there should be no relaxation of the no-benefit rule. The second submission we would make is, what would be the competence of Treasury or otherwise to determine whether there should be profit or not? This is a question ultimately for this court to determine, not for, as it were, an agency to be satisfied that some level of profit is warranted or not.
Well, you may be correct in that, but isn't that a question for the future? Once the disclosure is made about what expenses, income and net profit has been made for the 5 years, and a similar disclosure is ordered in regard to any extension that we may or may not order. When that happens, then the question arises whether there has been an undue benefit. And isn't that the time when it should and can be sorted out?
Justice Frenneman, there are powerful reasons we would submit not to engage in an ex post determination of undue benefit for a number of reasons. The first is that when parties are going into a contract, they have to have some basis for knowing what reasonable expectation they have of both revenues and ultimately potentially profit over the time of their ongoing incumbency in the arrangement. To have a situation where after the event, one then tries in accordance with an ex post facto principle that is enunciated as to whether the no benefit rule should be changed or modified, doesn't help anyone because they need certainty. That is to say, the Minister and SASSA need certainty as to how they can approach this contract, and so too ultimately does CPS. So our submission is twofold. One, as a matter of principle, it isn't warranted, because the no-benefit rule should be maintained. There is no reason why they should accrue a further profit. As a matter of principle, the court should announce that principle in advance so that all parties know where they stand. And secondly, to do it on a retrospective basis is itself somewhat illusory, because the question is going to be in the negotiations immediately, as we can already see from the papers, that CPS is stipulating for what it says must be the price per beneficiary regime, and then it is stipulating for a regime that will apply even as their services taper off. Now, the question is whether that should be paid to them, and whether it involves profit or it doesn't involve profit. So it's going to be very difficult for the authorities to know, as a matter of constitutional principle and obligation, what can CPS legitimately ask for and what can be agreed upon. If it is said, well, we're not telling you whether it's right or wrong now, we'll determine whether it's right or wrong after the event, and we'll leave it to the parties to arm wrestle as they might in a private law context to see where they can get to. This court has already enunciated the principle in All Pay 2 that it is precisely because of the power that CPS is invested with through its incumbency, and seemingly now the wide recognition that it is the only party that can render the service for a period, that it is vested with enormous negotiating power. And I'm going to take the court to the passages in the correspondence that has already taken place, where, amongst other things, CPS said on the 28th of December, we must have a contract in 2 days, or otherwise we're going to walk away from all of this. It has used its position systematically in order to try and exact a benefit which is utilized in these negotiations, and it's that precise power that this court sought to discipline in All Pay 2, and we again suggest respectfully to the court that it should discipline this process again going forward, not retrospectively, and in accordance with a very general norm which would have to be ex post facto applied to a contract. One needs to know what are the boundaries and limits for CPS and the authorities going forward over the interim period.
Mr. Unterholt, If we were minded to adopt your first option, which you called the perpetuation of the suspension regime,
Yes.
I'm interested to know what the true juristic nature of that first option would be. Would we, one, be extending the existing contract, and then two, or also extending our declaration, or rather suspending our declaration of invalidity of that extended contract, extended by us, or shall we be creating a new contract, albeit on the same terms for the parties? Or what exactly shall we be doing?
Justice Madlanga, in our submission, it would be an extension of the existing suspension regime and the terms and conditions under which such suspension takes place. In other words, it's not making a contract for the parties or a new contract. It is simply saying that for the period of the suspension, CPS must continue to discharge this constitutional obligation under specified terms and conditions that are dictated by the court. It's not making a contract for the parties. It is determining how a state function as an extension of the state will be discharged by a party saddled with constitutional obligations. And so in our submission, the language of contract and autonomy and private negotiations is wholly unsuited to what this court is now considering and the remedial powers that this court is being asked to exercise.
Perhaps I will be repeating a question that I think was raised by my brother, Justice Froneman. See, the difficulty I have following that in juristic terms is the life of the existing contract is coming to an end on the 31st of March. And we suspended our declaration of invalidity. But obviously that would have endured for the life of the contract.
Yes.
Now, logically, that suspension also must come to an end with the coming to an end of the life of the contract. How does that suspension make the leap to a point beyond the life of the contract? That's the juristic issue that I have.
Yes, Justice Madlanga, the question is the contract driving the suspension, or is the suspension driving the contract? In our submission, it is the court's power to determine the period of the suspension, just as happened in Zondi's case, which then determines the consequences for the contract. So, to the extent that the suspension is extended in order to allow a longer period to restore legality, then the question is, well, on what terms does that extension of suspension take place? And yes, it would have the consequence that it would be saying either one practically says the contract as it continues on the existing terms and conditions, but that's just another way of saying that the constitutional obligations that CPS has as captured in that contract must be perpetuated for the further period of the suspension. So in our submission, one thinks about this from the perspective of constitutional remedy, not from the perspective of private law entitlement. And once that is so, perhaps some of the juristic complications seem less onerous to resolve.
No, before you go any further, your exchange with my brother just triggered something, and it is this. Was it open to this court to order that this contract comes to an end before the 31st of March by reason of its illegality or invalidity?
Yes.
And was it also, I'm not sure, I really want to know, was it also open to this court if, say, told that it would take much longer than the lifespan of the contract to do what needs to be done to appoint or to contract validly with another party to then extend the lifespan, or the life of the contract way beyond the 31st of March 2017?
Yes. In our submission, the court would have had the power, assuming the court was convinced in All Pay 2 that there could have been a very short period before a proper tender was heard and the resumption of legality could be restored, assuming those were the facts. Then this court would not in any way have been bound under the terms of the suspension to say that CPS must see out its existing contract to the end of March 2017. The court would have said the contract serves the constitutional remedy, not the remedy the contract. So there could have been a termination of that contract which would coincide with when the suspension must end for the perspective of restoring legality. And similarly, the extension is equally within the court's power, because all that the contract is giving expression to is the need to secure an answer that gives expression to the rights of recipients to get their grants and the obligations of CPS to deliver those grants as a result of its incumbency.
I'm trying to think aloud through you, which I suppose I'm entitled to do. If it were a piece of legislation that is declared invalid by reason of its inconsistency with the Constitution, that piece of legislation or a section ceases to be alive as soon as a declaration of invalidity is made.
Yes.
And whether we suspend the declaration of invalidity for 6 months, 12 months, 18 months, or 24 months has got nothing to do with the lifespan of the legislation. It's the discretion of the...
Absolutely.
That's your point.
That is our point, and in the Zondi case, when the initial period granted by the court was not utilized properly by the government in order to put in replacement legislation, the court said, well, we've got an obligation in those circumstances to extend the period of suspension.
I'm putting these questions to you to understand. I've seen under some much earlier as an advocate, judges arguing through an advocate. That's not what we are doing here. So the lifespan of this illegal contract has got nothing to do with a period over which we've kept it alive.
Yes. Because the keeping of
the original intended lifespan is not a determining factor.
Because the contract is simply is just a convenient form to give expression to the constitutional obligation that CPS has. The court could have chosen other terms upon which the obligation was to be discharged, but it seemed convenient at the time to simply extend it on the existing terms.
So, Mr. Unterholter, you are effectively saying, at the time we made our order, remedial order that is, we could just as well, even though the term of the contract was 5 years, we could easily have said, we suspend our declaration of invalidity for 12 years. Yes. Effectively meaning that now we would be giving CPS a 12-year contract when all it ever bargained for was a contract for 5 years.
Yes.
Is that what you are saying?
There's an odd sort of shifting of terrain here, because at the time that the original order was made, the question is, why should CPS be advantaged with getting, as it were, the benefit of a bargain to which it was never entitled?
I'm just testing the principle now, based on your responses to the Chief Justice. Could we have said we suspend for 12 years, despite the fact that all it could ever have gotten out of that contract would have been 5 years, nothing more?
Yes. Justice Madlanga, I'm endeavoring to answer the question. One of the considerations at the time that one makes the order, probably the principal one, is how long does it reasonably take to restore legality, and how long are we going to hold the party to the constitutional obligation until legality can be restored? We recognize that that should be no longer than necessary if the no-benefit principle is being recognized. Curiously, at the time that the order was made, the concern was that CPS was getting the whole benefit of an illegal contract to which it wasn't entitled. Now, of course, the argument is being put slightly differently. How can we expect it to carry on doing this as a compulsory obligation to render the service? Because isn't it too burdensome? Last time it was, isn't it getting too much? Now the concern is, isn't it being left with too little? We submit that, of course, one will think about the incidence of the obligation and how burdensome it is. That's a consideration to have, and so on. But we say the no-benefit principle says they can neither gain nor lose from discharging the obligation. They're doing a public service as an extension of the state, and the books must simply balance at the end of the day. They mustn't be worse off, and they mustn't be better off. And what can be the objection to putting them in that position? If I may then proceed with what was the second part of my address to the court, and that just concerns some of the features, and I'll try and summarize it in less detail than I had initially thought, just in respect of the particular questions that arise as to the relief that we are seeking.
Before relief, you said that there was a threat to pull out of a contract and you were going to refer.
And I am,
can you just highlight that?
Yes, I can do so. The CPS has contended that it is that everything about the situation is something that is not of its making, but of the making of SASSA and the minister, and it is simply caught up in unfortunate circumstances that are not of its own making. But could I ask the court, and the pagination of the record is a little bit difficult, but I am dealing with the relevant correspondence is that of CPS, at least in my record, under partition G, where correspondence is to be found attached to CPS's answering affidavit. And this is some of the correspondence that has flowed between Net1, which is the holding company of CPS, and
sorry, Mr.
SASSA.
Is that CPS's answer to Black Sash or to FUL?
It's to the Black Sash application. So in our pagination, it commences at G1, but I'm not certain whether the court has the same pagination. It's volume G or G1, but in any event,
just make your submissions, we'll locate.
Yes. What one will find in this is that, if I could just very briefly tell you what happens, in May of 2016, CPS raises the question as to the fact that that time is running out, and it's critical for SASSA to decide on the way forward in order to prevent disruption of the payment process. This is in May 2016. Seemingly, they get no answer to their concern as to what is going to happen when the contract runs out. And nothing happens, at least on the record of things as we have it, until a letter is again sent by Net1 or CPS on the 9th of December 2016, which is some 6 months later. So CPS does nothing. They don't seemingly send follow-up letters. They don't approach the court. They do nothing of the kind. They then simply send another letter. But they do recognize in this letter that the Constitutional Court has found them to be an organ of state for the duration of the contracts, and that they can't walk away. So they're alive to the fact that they are burdened with this constitutional obligation, and now they're worried about what they're going to do with this obligation, given that time has now run by. One of the things that they say, and this you will find at the end of their letter of the 9th of December, is that, and this is in the second last paragraph, they say that Should you be of the view that the emergency and contingency plans described above are in line with SASSA's transition plan and your vision for the future, please inform us by the 19th of December to ensure, A, these plans can be implemented, and B, for us to reschedule the liquidation of the CPS subsidiary. So they are positing to SASSA that unless SASSA acts, they have it in mind that they are going to liquidate the company and thus destroy the resources that will make it possible for them, saddled with this obligation, to discharge that obligation. So that's the first thing that they say. It stands in some contrast to what they say in their answering affidavit, where they talk about the fact that among the costs that this court should bear in mind is what they call an opportunity cost, which is to say they would be better able to use these resources applied to some other commercial opportunity rather than being held to an extended contract, which would suggest the opposite of liquidating the assets, but actually applying them to a different commercial end. So they are somewhat at odds with themselves. But what is then important is that on the 28th of December, 2 days before the end of the year, they then write another letter to SASSA. And this has some, we would submit, quite clear and explicit efforts on their part to use bargaining power to secure terms and conditions favorable to them, which is precisely the risk that this court recognized in All Pay 2 and which it sought to eliminate as an ability of an incumbent to exact special terms through its bargaining power. What they say in the third paragraph at page of this letter on the 28th of December is that, as mentioned in my letter to the Minister, we can accommodate your first request as long as we finalize a new contractual arrangement before January the 1st. So they come along and they say, on the 28th of December, basically you've got 2 days to finalize this agreement. A party who lacks negotiating power could never make such a threat, and this is a clear manifestation of their power, and it's precisely this kind of power which we submit the court must seek to discipline. But what they then go on to say is, as we commence the closing down of CPS, exactly in accordance with what they claimed about liquidation, our service levels will gradually approach those stipulated in the service level agreement due to the reallocation of CPS staff. And then they say this: we hope this return, in inverted commas, to standard service levels will not cause any major disturbance or create any unwarranted burdens for beneficiaries. So they're basically saying we're going to start tailoring down our services, and we hope, but don't assure or say, but rest assured beneficiaries are safe. They say we hope it won't cause major disturbances. Again, there is an implicit threat that rests within that sentence. And then lastly, and this is particularly relevant to the questions posed to me by Justice Fruneman, we then see, having laid the groundwork of how there must be a contract, it's got to happen in 2 days, we're going to otherwise be scaling down and there could be some diminution of service to beneficiaries, they then come up with their pricing proposals. And this is where you will find that they are proposing to increase the rate from 16 Rand 44 either to 25 Rand, or if there's a 90-day rolling commitment, or 22 Rand if there's a 24-month commitment. Now again, they are stipulating for prices which involve very substantial increases, and they never say, but of course, because we carry constitutional obligations, we are telling you that we ask for these prices because there is no benefit, there is no profit, this simply covers our costs. They don't say it in these letters, and they never say it in the affidavits before this court.
You said 24 months is 20 Rand.
24 months is 22 Rands.
And then 25 is for what?
90-day rolling commitment is 25 Rand. And just to give you some sense as to what that means of an increase, that is the difference between 800 million and approximately 1.2 billion Rand. We are talking about enormous sums of money. It looks modest when you express it as an amount per beneficiary. But if you talk about the increments over the contract, we are talking about the disposition of huge amounts of public resources through a bargaining position that is being taken.
Mr. Interato, sorry to interrupt you, but where is this leading to? Where does it take us to?
I had asked for it. I had asked for it.
The Chief Justice asked me to indicate where in the papers we would find. Let me just give you the last two references, and then I will try and return to my text. At the end of this letter, there is what in our submission is a truly extraordinary proposition that is advanced in respect of price, because before the heading technical information, the CPS says that they will get the per beneficiary rate, and then they will cap the amount at that rate, even though thereafter the services levels that they will offer as SASSA takes on more responsibility will taper off. So they're going to earn hundreds of millions of rands at a capped rate, even though over time they will render less service. Now, at least on our reading, that is simply an effort to exact very considerable profits through the pricing proposal they make. And what we don't see is SASSA or the minister saying, but on what basis should we entertain these proposals? Where is the recognition of the no-benefit principle? And Justice Groneman, perhaps just to see why some of this may be relevant, if this court does not pronounce on whether the no-benefit principle holds or some variant of it, then there will be negotiations of this kind, huge amounts of public monies will be paid, and then there will have to be some retrospective reckoning on a principle ex post facto enunciated, and we say that is an undesirable state of affairs. So serious did SASSA take these proposals that that's precisely the proposal that they take to Treasury and say this is the indicative pricing that is being indicated, and that you will find as the last attachment to our affidavit, where we attach the letter from SASSA to Treasury. And then finally, there is one final passage which I would just reference for the court. On the 16th of February 2017, again CPS writes to SASSA where they say this. They say, it is our view that SASSA can enter into a new agreement with CPS on the basis of an emergency, which this is. We know Mr. Trengove has taken a different view on that matter, which SASSA appears to accept, but would find it difficult to enter into an agreement with any other service provider without going through a formal tender process. You'll have to go through a formal process, so you must deal with us, and by the way, you must deal with us quickly and on the terms that we've proposed, because you have no alternative. And it's precisely to remedy the gun to the head that CPS is again seeking to use for the purposes of exacting commercial advantage that we say should occasion this court's concern and proper remedies to prevent that form of abuse taking place when CPS discharges its constitutional obligation. If I could
before
yes.
you proceed, I think in all fairness to CPS in relation to the reasonableness of the prices, they do try to explain that in the affidavit in paragraph 20.
They do, but the difficulty that we have, as we've pointed out in our heads of argument, they have very limited and selective disclosures of the financial position that they would find themselves in. What, in effect, they say two main things in their answering affidavit. They say, firstly, that there have been CPI increases in respect of certain cost variables, and there haven't been adjustments since 2012. That's the first thing they say. And they challenge our proposition, though they don't provide any substantiation for it, where we say, as our expert persuaded this court in All Pay 2, that they turned profitable from year 2 of the 5-year contract. And all they say is they weren't profitable after year 2, but they never and assiduously avoid explaining to the court, well, at what point were they profitable? What were those profits? And what would the break-even point be if they had to render services for the future? And we
accept that there seemed to be some merit in some of the amendments that they made in relation to the lifespan of the IT and the fact that there has been some increase in inflation, as well as the fact that some of the smart cards may have to be replaced. So there's no benefit there.
Well, Acting Deputy Chief Justice, of course there are, in assessing this, different variables that will be relevant. But what one would have to look at if there was going to be a proper disclosure as to where the break-even point would be for a contract, say, for the next 12 months is what revenue would you need to meet your costs? We made the case that most of the costs were sunk costs which occurred at the outset of the contract and were worked out after 2 years. That's what our expert said, and it appears that the court accepted it in all pay too. Now, if they now wish to come to court to say, no, we were not profitable from year 2, and in order to sustain profitability, in order to sustain profitability, we would need a particular level of revenue, then they had to come to the court to say that. All that they have said is they've addressed selective variables, but never given you the picture. And I'm sorry, I said our expert. It's actually the expert that served before this court for all pay in the proceedings, where on a careful analysis of the financial information, it became plain that they were profitable after 2 years. And
let me just interpose. In the event we extend our order, will it still be necessary for us to grant you the relief you seek in relation to disclosure?
Yes, it would be, because it depends which of the various orders one is talking about. If the only remedy that issues from this court is simply that the existing contract carries on for a 12-month period, then there would still be need for accounting at the end of the period, because if the no benefit principle is upheld as of ongoing